So listen, bro, if you was one of them crazy kids like me, man, young and just mischievous and always into something, then you couldn't resist hitting that number that you knew you were not supposed to call. What was that number, y'all? 911. 911, bro. You knew better. As soon as you hear them answer, you hung up. They called back. You try to run in the room and hide like you didn't know what happened. They come in the room and ask you, did you call 911? No. We all, and I ain't gonna say we all, but a lot of us did it though. A lot of us did it. You know what I mean? So when I see this false 911 call leads to huge lawsuit, I'm like, first thing I think of was me as a kid. Then I'm like, but you doing this as an adult? What's wrong with you? What's wrong? But still, can't have no judgment. So shout outs to Audit the Audit, man. If you haven't shown them some love and go subscribe, go do so. They have a ton of great videos, man. And a lot of them you can learn something from. I'll always take something away from one of their videos, all right? And if you haven't subscribed here, what are you doing? Hit that subscribe button, join the fam, and we need you to do one thing once you do that, all right? But first, moment of silence for the haters. Run the lights up, baby. Let's go. Disclaimer.
Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers personal property, false 911 calls, and hate crimes, and is brought to us by both Police Activities Channel and Cleveland.com's channel. Be sure to check out the description below and give them the credit that they deserve. In the spring of 2016, 41-year-old United Arab Emirates citizen Ahmed Al-Manali and his wife temporarily moved to the United States while Mr. Al-Manali underwent medical treatment at the Cleveland Clinic in Ohio. On June 29th, 2016, Mr. Al-Manali traveled to the Fairfield Inn and Suites in the nearby town of Avon to seek accommodations, but was informed that they were fully booked due to the Republican National Convention taking place in Cleveland at the time. Mr. Al-Manali asked the attendants at the front desk for recommendations for hotels that may have vacancy, and the attendants told him to wait in the lobby while they print a list of hotels that he can call. As Mr. Al-Manali took a seat in the lobby, the Avon Police Department received a phone call from one of the attendants' sister.
Avon Police Sergeant Ruppel.
Hi, my sister works at the Fairfield Inn on Colorado Avenue in Avon. She is a desk worker.
Okay.
So there is a male in a full headdress with multiple disposable phones pledging his, pledging his allegiance or something to ISIS.
Okay.
And is very panicky.
The attendant's father also called and verified everything that the previous caller had reported.
She said she's in the back. I have the text. She said she's terrified, so please.
Oh, okay, all right.
Thank you.
Avon officers arrive on the scene minutes later and detain Mr. Al-Manali at gunpoint. Once the officers place Mr. Al-Manali into handcuffs, they begin searching his pockets.
She said she's by herself.
Not good this.
Oh, bro, this is way more serious than I thought, fam. What did they just do, bro?
I'm tourist, and this is good, not good.
Yeah, it's not good. It's right. Make a sweep this place. I don't know. It's got it up. 54. She said she came by her. She said he's by himself. Anybody else? She said he's by himself. So if this guy down, make sure he's got nothing on. We look. Relax. We look good. Relax.
Embassy.
Lift your leg up.
Says he works for the embassy.
That's nice. Lift your leg up.
Broken my telephone also.
Yeah, you broke my nail.
During the search, one of the officers tosses Mr. Al-Manali's phone, and in later footage, it appears that the phone was broken. It is widely accepted that police officers can cause reasonable and necessary damage to an individual's personal property during a search based on a warrant. For example, in the 1979 case of Dahlia versus United States, the Supreme Court held that, quote, "It is generally left to the discretion of the executing officers to determine the details of how best to proceed with the performance of a search authorized by warrant, subject, of course, to the general Fourth Amendment protection against unreasonable searches and seizures. Officers execute..."
Basically saying you can imagine why they are not caring about. Look at the call they received. Always, if you're getting pissed off at the cops right now, you got to go take a step back further than that and say, the call that was saying this guy and what he was doing. So in their mind, they need to get there quick, try to stop this, figure out what's going on, and intervene. You know what I mean? So you, in this situation, you can't really, so far, you can't knock the officers for being aggressive, for trying to see what, you know what I mean? It's the call that came through dispatch that got them riled up.
Executing search warrants on occasion must damage property in order to perform their duty. However, in the 1998 case of United States versus Ramirez, the Supreme Court clarified that, quote, excessive or unnecessary destruction of property in the course of a search may violate the Fourth Amendment, even though the entry itself is lawful and the fruits of the search are not subject to suppression.
Now, don't get it confused. Don't think I'm saying that he shouldn't have his phone replaced. Oh, absolutely. Anything that's broken or damaged should be replaced by them because that happened. You know what I mean? But let's see where this is going. Let's see where this is going. This is crazy.
The Fourth Circuit Court of Appeals applied the holdings in these two cases in the 2020 case of Cybernet LLC versus David, stating that, quote, during the course of a search, incidental damage to property may occur. This is not at all to suggest that officers may ransack premises at will. Whether property damage is constitutionally excessive is most comfortably assessed under a standard of objective reasonableness. Thus, we hold that an officer's conduct does not violate the Fourth Amendment if the destruction of property is, as an objective matter, reasonably necessary to execute a lawful search warrant. Courts have generally also concluded that probable cause to search justifies the reasonable and necessary destruction of property, as the Eighth Circuit Court of Appeals determined in the 2008 case of U.S. versus Santana Aguirre, holding that, quote, consensual searches generally cannot be destructive. Cutting or destroying an object during a search requires either explicit consent for the destructive search or articulable suspicion that supports a finding that probable cause exists to do the destructive search. While the federal circuits do not agree on whether a general consent to a search includes consent to damage personal property as part of the search, even the circuits that allow damage to an individual's personal property during a consensual search agree that the damage must be reasonable and related to the search. Because there is no reasonable basis for which the officer needed to throw Mr. Al-Manali's phone as part of the search, a court would likely find that its destruction was a violation of the Fourth Amendment. As Mr. Al-Manali is searched, one of the officers enters the hotel to speak to the staff members who prompted the 911 call.
Somewhere in Avon or Elyria. He wanted a month's stay. He was leaving July 13th to the 14th, around there, and I tried to help him as much as possible. Everyone said that they were booked and they couldn't help him. I told him, and then he wanted to sit in our lobby. He didn't want to leave.
So you said you guys were booked?
Yeah, we said we were booked.
Okay.
And everywhere he called is booked too. It's summer, people are
Sure, absolutely.
So, I mean, that's what he had two phones. He was searching the internet on one phone, making calls on a disposable phone. That's really all that I know. It just freaks me out because of everything.
He didn't say anything else?
No, it's
Because the call we got is that someone said that he was pledging his allegiance to ISIS,
No.
Who would have said that? Who made the call?
I told my sister, I said, he's dressed in, it's my sister, her name's Allison. She called, I said, he's dressed in a weird outfit, he has two disposable phones. I said, I don't know what to do because of everything.
2030 units, stop your search.
Holy. Oh my. Are you kidding me, man? Are you kidding me, bro? Are you kidding me? Because of what he was wearing. He never said anything just because he had two phones. Bro, when you're misinformed, keep your mouth shut. When you're misinformed, keep your mouth shut. You can't make it more simpler than that. Reason why I say that is take any one of us, put yourself in that guy's shoes right now. You would be livid. You would be livid. So don't try to justify it. Don't try to make excuses for. You would be livid if that was you. Cops rolled up, harassed you, put you in handcuffs, violated you, searched you, damaged your possessions, and you're looking like, what is going on? What did I do? What did I do? You would be livid. Keep that in mind before you make your comment.
Yeah, we're good. Hey, your LT's back up. We're going to sweep the lot real quick. Okay. Right here. It's a bunch of SIM cards. He has them all right now. Just put like 6 or 7 different ones. Amherst. Flea Market. He had this thing in here.
Because everything is going on with ISIS is what I said. I said, call the police, because we couldn't, because he kept coming up here.
Stand down, stand down, stand down.
The front desk attendant informed the officers that Mr. Al-Manali never pledged allegiance to ISIS, in direct contrast to the information her sister provided during the 911 call. Section 2917.32 of the Ohio Revised Code, which defines the crime of making false alarms, states that, quote, no person shall report to any law enforcement agency an alleged offense or other incident within its concern, knowing that such offense did not occur. Similarly, Section 128.32 states that, quote, no person shall knowingly use the telephone number of a 911 system established under this chapter to report an emergency if the person knows that no emergency exists.
What if they'd have came out there and he would have been having a bad day and they're like, get down on the ground, and he's like, no, for what? I didn't do nothing. And they think he being combative, he gets shot, dies, all because of a false 911 call.
Therefore, under the Ohio law that applies to making a false 911 call, the attendant's sister could only be charged criminally if she made the call knowing her allegations were false. In order to convict an individual of a criminal offense, the government must prove that the individual both committed a criminal act, referred to as actus reus, and that the individual had a criminal mental state, which is called mens rea. The mental state required for a conviction varies from crime to crime and is defined by statute. For Ohio's making false alarm statute, the mens rea is knowingly, which, as section 2901.22 of the Ohio Revised Code explains, means that, quote, a person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and fails to make inquiry or acts with a conscious purpose to avoid learning the fact. Under this standard, the attendant's sister could not be prosecuted for making false alarms based on her allegations if the 911 call was simply the result of a mistake or misunderstanding. However, if enough evidence existed to prove that the sister knew Mr. Al-Manali probably didn't pledge allegiance to ISIS and she made the call anyway, she could potentially be convicted for making false alarms.
I'm so sorry. It's because he kept coming up here and asking questions and stuff like that, and we couldn't.
Well, unfortunately, the call that came to us was that he was screaming, pledging his allegiance to ISIS and waving his phones around. That's a very big, different picture than what happened.
He did have 2 phones, but he was talking to a guest out here in the lobby who was trying to find some directions, and I think I've got that card up there. It was a Hirschenberger Organic Farm 1557.
Okay. Well,
just printed.
When did it become illegal to ask questions? Somebody.
I'm not saying it's nothing, but the call that we got is nothing what happened, so I think things got a little blown out of proportion.
Oh, I apologize.
Someone dressed like that just holding phones isn't enough to call and say they're pledging their allegiance to ISIS. That's a totally different ballgame.
Right. Well, I didn't know who the
All right, just sit tight. Nobody leave.
Okay.
Let me go try to smooth things over with this gentleman.
Okay.
Nobody ever said anything about ISIS. She called her sister because she was nervous because he looked like that and had 2 phones. So let's go dust this gentleman off.
The attendant admits that she was afraid of Mr. Al-Manali because of the way he dressed and the fact that he had 2 cell phones, which could be considered a form of religious bias. Hate crime legislation, which exists on the federal level and in the vast majority of states, either makes the punishments for certain crimes harsher if they are motivated by a bias against a protected group of people, or creates new crimes that include a bias motivation as an element of the offense. Section 2927.12 of the Ohio Revised Code defines the crime of ethnic intimidation as committing aggravated menacing, criminal damaging or endangering, criminal mischief, or certain types of telecommunications harassment because of the race, color, religion, or national origin of another. Federal hate crime legislation, which is applicable in every state, includes Section 249 of Title 18 of the United States Code, which criminalizes causing or attempting to cause bodily injury to another because of their actual or perceived race, color, religion, national origin, gender, sexual orientation, gender identity, or disability. Because neither the state nor federal hate crime laws apply to making false alarms, even if the 911 caller was convicted of this offense, she could not also be charged with a hate crime if her actions were motivated by religious bias.
I'm sorry. She should have been charged. And I know they know a lot, way more about the law, and they're going by the book, but she should be charged, bro. Because this is she's fortunate that this went the way that it did, even though it shouldn't have never happened. This could have been extremely bad. The outcome of it could have been deadly. A lot of things could have happened that didn't, thank gosh, but it could have been, bro. It could have been way worse. Way worse. Depending on the officer that showed up, depending on what he did when they showed up, like the outcomes could have been, you know what I'm saying? It's not right.
Stand. Uncuff him. So your brother's not here? He's not a brother. He can't speak.
After receiving the order to stand down, the officers returned Mr. Al-Manali's property and released him from handcuffs. Eventually, the officers recovered one of Mr. Al-Manali's phones that they had thrown into the bushes nearby, and he was able to call a friend of his, who was also a police officer, to translate. As the officers were speaking to Mr. Al-Manali's friend, he suddenly collapsed and lost consciousness. Luckily, a fire squad was already on the scene, and they began rendering aid immediately. Mr. Al-Manali had just undergone open heart surgery a few months prior to this interaction, and he was hospitalized following this incident after displaying symptoms of a stroke. Mr. Al-Manali was released a few days later, and he went on to file a lawsuit against the Avon officers and the hotel, which was owned by Marriott International Inc. The Avon Police Department issued a formal apology in person, and initially stated that they would consider bringing charges against the 911 callers.
Well, see, that's the thing. They should have gave him the option there. Well, he passed out. Or once, you know, he came to, or he was better in the hospital and they could have went up to see him. He should have been given the opportunity. Do you want to press charges for anything that happened to you? He should have been given that option then.
In person, and initially stated that they would consider bringing charges against the 911 callers. The Lorain County Prosecutor's Office investigated the incident and presented evidence to a grand jury, but the jury declined to indict them on any charges. Mr. Al-Manali's lawsuit was initially seeking $200 million in damages, but after a 3-year-long court battle, he eventually settled for an undisclosed amount in 2019. Overall, the Avon officers get a C+, because although they apprehended Mr. Al-Manali appropriately based on the information available to them at the time, they also demonstrated a reckless disregard for the safety and security of Mr. Al-Manali's personal property. As we have discussed previously on ATA, the chain of communication between 911 callers and police officers is often riddled with inaccuracies and tends to dictate the overall tone of almost every interaction. It is difficult to fault the officers for responding in full force to a report of a potential terrorist attack.
Exactly. I agree with that. It is. I don't even care about the letter grade he gave to them because they don't deserve it really because of the call that came in that had them hyped, need to get here. You know what I mean? They probably wasn't thinking about a phone. You know what I mean? Phones can be replaced. You know? Material things and stuff can be replaced. You replace his stuff that y'all damaged, y'all replaced it, get him some new stuff. You know what I mean?
And I commend the officers for having the patience and discipline to detain Mr. Al-Manali without violence. It should also be noted that Mr. Al-Manali was only in handcuffs for approximately 7 minutes before the officers were able to figure out that it was a false 911 call and released him. All that said, the officers also made a few disrespectful remarks and destroyed Mr. Al-Manali's phone for no apparent reason. It could be argued that the officers tossed the phones to prevent the activation of a device, but the same goal could have been achieved by simply removing the phones from Mr. Al-Manali's possession. The officer's complete lack of compassion after destroying the phone adds merit to the notion that the officer did so maliciously. Most of the Avon officers did their job efficiently and professionally, but a few of them could certainly be reevaluated. As for Mr. Al-Manali, I cannot rightfully issue a grade to an individual who was a victim of a false 911 report based almost purely on his appearance. Mr. Al-Manali is also not a native of the United States, so he may lack the necessary societal and cultural context to fully understand the civil liberties associated with the Constitution. Despite the chaos of this interaction, Mr. Al-Manali managed to remain calm and composed the entire time, and complied with the officers without resistance. As mentioned in a previous episode of ATA, understanding the civil liberties afforded to citizens and visitors of different countries would require intimate knowledge of the country's history, political landscape, and current state of policing, and Mr. Al-Manali is not required or expected to know these things before visiting the US. It was later alleged in Mr. Al-Manali's lawsuit that the desk clerk who was questioned by the officers did indeed send a text message to her sister and father stating that Mr. Al-Manali was, quote, declaring himself to ISIS. There is no doubt some degree of injustice remains in the wake of this case, but I commend Mr. Al-Manali for following up this encounter with the proper legal action and securing compensation for his experience. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't...
No, I want to know what happened to the clerk. Besides her getting fired, was there charges? Or maybe I missed that part. It's wrong. That was foul, bro. That was foul. Like I said, that could have been bad. And you see how he passed out? Yeah, that could have been very, very, very bad, man. Y'all get at me in the comment section. Let me know what y'all thought of this video, man. This one right here hurts to see. It hurts to see. But we need to look at it and be able to face it so we can talk about it and stop these type of things from happening. It's your boy L, man. Y'all get at me in the comment section. Let me know what you think, man. Until the next reaction, I'm out. Peace, y'all. Stay solid. Ayy.